The Trump hush money case. So the jury verdict is in. Trump's been found guilty. Look, this is a momentous case. Everybody's talking about it. Most people don't fully understand it, but here's something we all know. It's a dangerous precedent. Nobody wants it to be the rule in America that if you're a former president or if you're running for president, you become a target for criminal prosecution. It is hugely important that if there is a criminal prosecution, it be done lawfully and constitutionally. I'm Jed Rubenfeld. I'm a law professor at Yale Law School. I write and teach and litigate about constitutional law. And I'm going to tell you that there are some serious constitutional problems with this case. But I'm going to lay it out for you without any partisan bias, I hope, and I'm going to take you through it. Also, I'm going to tell you what I would do if I was Trump's lawyers right now, because I have some ideas about what they might do that you might not have heard before. But I'll get to that at the end. Let's get the simple stuff out of the way first. Can Trump still run for office? Yes, he can. Could states decertify him? Could they take him off the ballot because of this prosecution? No, they cannot. That's straight up unconstitutional. If you're found guilty, even of a felony, you can still run for president, and states cannot try to take you off their ballot. Could Trump run for president if he's in jail? Yes, he could. Back in 1920, a guy named Eugene Debs ran for president from the jail cell of a federal penitentiary. He got almost 1 million votes, about 3% of the vote. So it can be done. Okay, that's actually the easiest stuff here to answer. Now let's turn to a harder question. What exactly was Trump just found guilty of? Now, normally in a criminal case, that would not be a tricky question. The defendant was found guilty of robbing some bank on some particular day, and if he's found guilty, and you know what he's found guilty of. That is not quite the case here. It's not anywhere near so simple. So was Trump charged with unlawfully having an affair? No, because that's not unlawful. Well, was he charged with hushing it up? Was he charged with paying money to keep that quiet? No, because that's not unlawful. Whatever you might think about it, paying hush money to keep quiet allegations of an affair or something else, there's nothing criminal, there's nothing unlawful about that. So what was he charged with? He was charged with a two-step crime. There's two pieces of it. Step one, falsification of business records. Falsification of what business records? It starts back in 2016 when Trump's lawyer, Michael Cohen, pays $130,000 to Stormy Daniels to keep her quiet, to get her to sign an NDA saying she won't publish her allegations about having had an affair with former President Trump. He was not then former president, but with Donald Trump. Cohen pays her that $130,000. Now, skip to 2017, Trump is president, and he starts reimbursing Cohen for the payment that Cohen made to Daniels. And he spreads that reimbursement payment together with other money that he paid to Cohen. He spreads that over 12 months, and that generates business records, checks, bookkeeping entries. And those checks and bookkeeping entries, they say that the payments are going toward legal expenses. Now, believe it or not, the whole case in the starting phases depends on this. Is there something false about saying that those payments were for legal expenses? The prosecution says yes, those are false statements. Why? Because the payments were hush money payments, and more specifically, they were campaign expenses. Expenses made to further his campaign. They weren't legal expenses, they were hush money campaign expenses. The other side, Trump's people, they say, what are you talking about? Those are payments made to Trump's lawyer for services he performed as a lawyer, so those are legal expenses. Believe it or not, you got to answer that first question. If you think those were legal expenses, then there was no false business record and Trump should not have been convicted. But lots of people believe, as the prosecution said, that no, those were hush money campaign expenses, not legal expenses, so they were false. Okay, that's step one, because Trump was not charged only with falsification of a business record. He was charged with falsifying a business record to conceal a second crime that he'd already committed. That's how the charges become felony charges. And if you're wondering, it's because he spaced out the payments over 12 months, generating like 3 business records each time, almost 3. You get to 34 counts of false business records. You may have read there are 34 counts. That's the 34 counts. But then the question is, what second crime is the state saying that he was trying to conceal through these allegedly false business records? So it's a two-step crime, falsifying business records in order to conceal a second crime that he'd already committed. So what was the second crime? Well, that's where things get tricky, because the indictment didn't say. The indictment said that he'd falsified business records to conceal a second crime, but it never said what the second crime was. And to this day, a lot of people are unsure what the jury thought, because what the state did was it did not commit itself to what the second crime might be. In its papers before trial, the state said, look, we got a bunch of different theories, and we got at least 3 theories. One theory was the second crime was a New York tax violation. One theory was the second crime was a federal campaign finance violation. One theory was it was a New York election law violation. And here's where things get even trickier, because the New York election law violation is itself a 2-step crime. It's the crime under New York law of trying to influence an election through unlawful means. That is, through violating some other statute, committing some other offense. And what happened was the state never committed itself to which of those crimes it was going to try to allege that Trump was concealing through these business records. And that went up right to the first day of the trial. But during the trial, the prosecution kind of narrowed it down to one of those 3 crimes. And the one it chose was the New York election law violation. But there, the problem was that, as I just said, that was another 2-step crime, where they had to come in and show that he was trying to influence an election through the violation of some other statute. And they never said exactly which other statute that was going to be. And to this day, we do not know what the jury was thinking when it convicted him. You can ask a jury for a special verdict and make the jury say exactly what offense the jury believes the defendant to have committed. But the judge did not order a special verdict in this case. The judge ordered what's called a general verdict. And on top of that, the judge told the jury, you know, when it comes to that election law offense with its second crime, you don't have to be unanimous about that. 2 of you could think that Trump was trying to influence an election through a tax violation. 2 of you could think that Trump was trying to influence an election by falsifying other records. And a bunch of other people on the jury could think there was some other violation. And the judge said, you don't have to be unanimous about that. Is that constitutional? Can he do that? I'll be turning to that in the next part of this show. But for now, you understand the basics. The jury convicted him, or found him guilty, of falsifying a business record to conceal a second crime that he'd committed. And we think, although you can't be totally sure, that that second crime was a New York election law violation, which itself required the showing of another legal violation, and we don't know what that violation was. Okay, part 2, the constitutional issues. A lot of lawyers say that this whole prosecution was unconstitutional. What are their arguments, and do those arguments have any merit? Well, the first thing a lot of people say is, you know what? This prosecution would never have been brought if it hadn't been against Donald Trump. We think that Alvin Bragg, the district attorney, we think that he brought this case because he's pursuing a vendetta against Trump, hates his policies, doesn't want him to be president. The whole point of the prosecution, people say, is to undermine Trump's chances of being president. Well, if that's true, does that make the prosecution unconstitutional? Answer, yes, it would. That's called, in legal terms, selective prosecution. The state cannot come after you with a criminal prosecution because of hostility toward or in retaliation against your political activity. That's unconstitutional. And if they're doing that, the whole prosecution is unconstitutional. Well, the problem here, though, is that's very difficult to prove. That gets into the motives inside the head of the prosecutor. Very tough to prove. In fact, some courts have held the only way you can prove it is by coming up with a comparable case, a comparator, a comparable case of somebody else that the district attorney could have prosecuted on very similar facts, but didn't prosecute because the district attorney liked their politics, but didn't like Trump's politics. Very hard to come up with a set of comparable facts like that. Believe it or not, there might be a comparator here. There might be a very similar, comparable set of facts involving Hillary Clinton. But that's going to get into too much factual detail that I don't have time for on today's show. Maybe in another show, I'll talk more about that. So constitutional issue number 1 is selective prosecution. A lot of people think this was an instance of selective prosecution, and there is some pretty good reason to believe it, but difficult to prove. Now let's turn to issue 2, the indictment. I told you before, the indictment charged Trump with a two-step crime, falsifying business records to conceal a second crime, but never said what that second crime was. Is that constitutional? Well, under the United States Constitution, under the Sixth Amendment, every criminal defendant has a right to know the charges against him. So how does that principle work in this kind of case? And I'll answer it by quoting from a federal case. The court was the United States Court of Appeals for the Second Circuit, and here's what the Second Circuit said. Where an indictment charges a crime that depends in turn on violation of another statute, the indictment must identify the underlying offense. That sounds kind of relevant, doesn't it? I'm going to repeat it to you. Where an indictment charges a crime that depends in turn on violation of another statute, the indictment must identify the underlying offense. Well, that's exactly what this indictment did. Charged a crime that depended in turn on the violation of another statute, but it didn't specify or identify the underlying offense. Now, there's a very good argument that that indictment was in violation of federal constitutional law under this Second Circuit case and many other cases that are like it. By the way, if you want to look it up at home, that case was called United States versus Pirro, P-I-R-R-O, 212 F. 3rd 86, I think, decided by the Second Circuit in 2000. Okay, so let's say that this was a defective indictment under the Sixth Amendment of the United States Constitution. Is that the end of the story? Does that knock out the whole case? Well, maybe not, because in the information, the state can provide other details about the crime and can fill in gaps or cure. And District Attorney Bragg, he did file an information on the very day the indictment was unsealed or made public. But the information also didn't say what the second crime was. So you got the indictment that doesn't say, and then you got the information that doesn't say. Well, is that the end of the matter? So now do we have a violation of the Sixth Amendment and the whole case is out the window? Well, maybe not quite, because the defendants are permitted to ask for another document. This document's called a Bill of Particulars. And in that document, the state, once again, can provide more detail. And in this case, the Trump team did ask for a Bill of Particulars. And they specifically asked, you got to tell us what the second crime is. Specify what the second crime is. But the state, District Attorney Bragg, arguing for the state, he said, no, we don't have to tell you. We're not going to give you a Bill of Particulars. Under New York law, we don't have to tell you what the second crime was. We don't have to specify the second crime. New York law allows us to prove that at trial. We've got a bunch of different theories what the second crime might be. And Judge Mershon upheld that view. He held that the state does not have to tell what the second crime was, and that it's okay for the state to have at least 3 different theories of what that second crime might be, and they can go forward with any of them at the trial. So right up to the day of the trial, the Trump team did not know what the second crime was going to be. As the trial progressed, it became clear that the state had honed in on that New York election law offense. But remember, that was itself a two-step crime, trying to influence an election through unlawful means by violating some other statute. And once again, there were a bunch of different theories about what that second, or in this case, third offense might have been. And Judge Mershon said that's okay. State can have a bunch of different theories of what that further statutory violation was. And the jury can pick and choose among them. Well, is that constitutional? I think there's a very serious question about whether that was all constitutional. Because you see, the Sixth Amendment requirement that the defendant be informed of the charges against him, that's not a mere technicality. It's actually like the fundamental principle of constitutional criminal procedure. If you're charged with a crime, if you're being prosecuted by the government, you have a right to know what it is they're charging you with, because we're not supposed to have a legal system like Franz Kafka's legal system in The Trial, where the protagonist is put through a trial and found guilty and never told what it is he's been charged with. It's a very serious matter to not tell the defendant exactly what charges he's up against. And that's why the Second Circuit held what it did in that Pirro case. Because the defendant has a right to know, to prepare his defense, to know what the crimes that the state is going to put before the jury might be, so he can call the right witnesses and be ready to defend himself. And because the state was playing hide the ball on this and changing its theories and keeping its theories open right through the whole trial, I think there's a very serious potential Sixth Amendment violation that happened in this case. Now let me move on to the unanimity issue. So remember, What Judge Mershon does is he tells the jury, okay, to find a violation of this New York election law offense, you got to find that Trump was trying to influence an election, namely his own election, through unlawful means, through violating another statute. But you don't have to be unanimous about what the other statutory violation was. Is that unconstitutional? Well, the Constitution does require a unanimous jury. And that requirement, that applies in state prosecutions as well as federal prosecutions. That's only been true for a few years, by the way. It's only a few years ago that the Supreme Court said that that unanimity requirement applies to state prosecutions, but it does to state felony prosecutions, and that's what this was. And so does Judge Mershon's instruction to the jury about non-unanimity, does it violate that principle? Well, it might, but this is kind of complicated, too complicated for me to go into here. There is a case to be made that that's an unconstitutional jury instruction, that the Constitution requires unanimity on that point. But I'd have to get into cases and complications I don't have time for right now. So I'm going to stop there. You got your three big constitutional questions: selective prosecution, failure to give notice of what the crime was. That's the Sixth Amendment violation. And finally, the danger of an unconstitutional, non-unanimous verdict, which might have occurred in this case. There are other errors that Trump's team, for sure, is going to allege: trial errors, evidentiary ruling errors, many other errors, and some of them might even amount to constitutional errors. But what I've done now is I've summarized for you three major constitutional arguments that you can be sure will be made by Trump's team when they appeal. Okay, part three, next steps. Now we know where we are. Where do we go from here? Could Trump actually be put in jail? You bet he could. Each count of this 34-count indictment has a maximum penalty attached to it of 4 years. Well, that's 4 times 34. That's a maximum sentence, prison sentence of 136 years. Judge Mershon could sentence President Trump to jail for 136 years. Will he do that? Of course not. He won't. But could he sentence him to some incarceration? Yes, he could. Will he? Nobody knows. A lot of people are saying, nah, he won't. He'll just impose probation or a fine. But the truth is, sentencing is left very much open to the judge's discretion. It'll all be up to Judge Mershon, and nobody knows what he'll do at this time. Now, when is sentencing scheduled for? Well, Judge Mershon has set it for July 11th. Will something happen between then and now? Yes. Trump's team will ask for a judgment notwithstanding the verdict. They'll ask for Judge Mershon to throw out the jury's verdict and find Trump innocent despite the verdict. And Judge Mershon will turn that down. Then there will be arguments about what the sentence should be, briefing on both sides, possibly even a hearing. Then on July 11th, sentencing will be announced. And at that point, that triggers the Trump team's right to appeal. To what court would they appeal? Well, they would appeal to New York's appellate level court. And they would make arguments of the kind that I've summarized to you, and other arguments as well. And they will say, throw out this conviction. And after the appellate court rules, then the case could go up to New York's highest court, which is actually called the Court of Appeals, but it's New York's highest court. And after that, the case could go up to the Supreme Court. And ultimately, it might well go to the Supreme Court, where finally we will have a definitive, conclusive ruling on whether the conviction was constitutional or not. Of course, that would take years. And that's a problem here. Why is it a problem? It's a problem because the election will have taken place. And if this conviction is unlawful and unconstitutional, it could have an effect on that election. There are surveys, many polls, in which a substantial number of American voters say they will not vote for Trump if he is convicted of a felony. Many independents say that. Many Republicans even say that. If that's true, an unlawful conviction in this case could interfere with and in fact decide the outcome of the next election of the next president of the United States. Even if the conviction were reversed on appeal years later, that effect could not be undone. In legal terms, that's called irreparable harm. The irreparable harm, once again, is that a convicted felon could affect the election, could decide the election. And if so, then District Attorney Bragg and Judge Mershon will have unlawfully interfered with the election and decided the outcome of the next election through unconstitutional means. And no years-long appeal could have any effect on that. Well, is that where we are? So are we stuck with that possibility? Well, believe it or not, there is one other avenue that the Trump lawyers could pursue. They could sue in federal court and ask for an emergency temporary restraining order. Restraining order of what? Well, let me tell you something that you might not know. You've probably been reading in the press, if you've been reading about this case, that Trump is already a convicted felon. The jury has convicted him. He's a convicted felon. Well, guess what? That's not true. You're not a convicted felon because of a jury verdict. You're not convicted unless the judge enters a judgment of guilt against you. The judge still has the power, as I told you before, to throw out that verdict and enter a judgment of acquittal. You are not convicted until the judge enters that judgment of guilt. Now, in New York, it's very likely that Judge Mershon will enter that judgment of guilt against Trump on the same day that he issues sentencing. That'd be July 11th. So what would this federal case be about? In this federal action, Trump would sue District Attorney Bragg and other state actors and ask the judge, the federal judge, for an emergency temporary restraining order halting Judge Mershon from entering that judgment of guilt until the federal courts have had an opportunity to review and rule on the serious constitutional arguments that exist here. And let me tell you why I think that might be a very important thing to happen. Because going after criminally a former president of the United States and somebody who is running for president now, that's a very bad look for this country. It's an especially bad look when the folks bringing the case and the judge deciding it are members of the opposing political party. And it's an even worse look when the crime is so unclear that the state is hiding the ball about what the actual charges are right up through the trial and indeed into the trial. And even now, we don't know exactly what the jury found Trump guilty of. If you're going to go after a former president and somebody who's running for president now, the poll leading candidate, if you're a member of the other party and you're going to do that, you better have the goods. You better not be pursuing some novel legal theory where you have to hide the ball. It's not even clear what the charges are. That could be a very dangerous precedent for this country, a very bad and dangerous precedent. And that's why it's so important for a federal court to review the constitutionality of this prosecution and decide, was it constitutional, was it not? To achieve that, the only way to achieve that before the election takes place is for the Trump team to file an action in federal court and ask the federal court to temporarily hold off the entry of the judgment of guilt until the federal courts and maybe the Supreme Court itself can, on an emergency basis, adjudicate the likelihood of success of these constitutional arguments. If that doesn't happen, then that irreparable harm danger that I mentioned before, well, that's where we are. But if it does happen, the nation could get a ruling from the federal courts, even the Supreme Court of the United States, before the election takes place. And maybe that's what the nation needs, and maybe that's what the law requires here. So if I were Trump's lawyer, that's probably what I would do. I would run into federal court, file this action under Section 1983, and ask for a temporary emergency restraining order. Will Trump's lawyers do that? I have no idea. But that's what I would do. And now I've come to the end of what I had to say today about Trump's guilty verdict in this case. I hope you've learned something from it. If you want to know more detail about it, well, tune into other episodes. Thanks for listening. Goodbye.